Rorick, the floor is yours.
Yes, thank you very much. You can sit here or there as you want. Well, hello everybody. My name is Rorick Tovar. I work here as a senior assistant at the Project Choice of Law Database at the University of Lucerne. What I will present you is what we can say our baby. This is a tool that we create, and this is a project in the project, and it consists of a tool able to extract information from judicial decisions and bring you this information translated in English. Which kind of information we provide you, I will explain you that in a couple of minutes. But what you have to understand is that when you are dealing with an international case, you have three problems. The first one, the language. It's very difficult to have this capacity to read the decision. The second, sometimes the decisions are like that, and you have no time in order to do that. And third, maybe you can do that, and at the end of the day, what is important for you is have a way how to triage, to know which decisions are important for your research. Because we are not trying to replace a human being. No, what we are trying is give you a tool that can help you. Like a co-pilot, an assistant that is able to say, well, from these decisions that you give me, this one is about that, the second one is about that, and then at the end of the day, you decide, and you have to read that at the end of the day. But not all, but a part of it. Well, I will start you with this case analyzer. Here, the first question is how does the tool work and what can it do? I have prepared just a video here. It's like you say, you go to Google, you go to our page, and then you select case analyzer. And then you have that. The only thing that you have to do is take a PDF and put there. And it start the analysis. I know that we can see exactly the content, but I will explain it out later with big letters. But here you have to say that it start analyzing, and here there are certain questions, and then it provides you this information. Ladies and gentlemen, there in your table you have this. You have, I think, a resume of the section. Yes, it's like that, and this is the information that it provides. Sometimes we have some of person this part of the project have English as mother language and can say, well, it's not perfect English because at the end of the day, that is an LLM who is doing that. But as I can show you right now here what kind of information it provides. Then please, Rodrigo, you don't have to read that now because I will show you exactly what is that about that. Well, what kind of information? Well, first of all, you can click here and print that this kind of information. But the most important is that you can send us that because what we are doing is that I provide you a tool so that you make your research, but maybe you are a collaborator for us and you find a decision that is interesting for commercial contracts and you click here and you send me that. Because I know who are sending this paper, I will trust on you and then we can make some things and introduce that in our database. Because of that, when Agatha was presenting, was saying that so this is a tool that the database is something that is in life. And every time we have more decisions and more information. Well, that is how it works. It's very easy. There's a PDF there, and they give you a summary. But the information that they provide is, first of all, the issuing country, which country is the decision coming, clearly. The second is the legal system. Well, we know that the legal system in Spain is civil law, in India is common law, but what happened? We have a decision from Ghana. Is Ghana civil law, common law? You don't know that. Or what happens if you have a decision from Canada? Because in Canada, there is two legal systems. Well, this machine is able, I will explain later how it works, to say you what kind of legal system it is. So that you have a better idea what is about that, the decision. Then it can give you information about the choice of law passage, because that is very important. We are talking about private international law, and in the reality, private international law is a sub-question. It's a preliminary question. The question is, will you pay that or not? The first question is, which law apply that? And finding this information just related to private international law is what our tool can do. Okay. I got that space? Okay, well, that is the third thing. The second thing that it can do is that it can give you the legal provisions. legal provisions related to choice of law. In a moment, I can give you an example of that. The conflict of law issue, that is the matter, the most important matter related to private international law, discuss it, and what is the position of the court. And of course, it gives you a abstract of the decision. Well, that is what it can do. And the next thing is what kind of information I can give you. For example, an example. I put here a decision like that was from Argentina. Of course, you have to put a PDF and you put there, and here start the abstract. Here we can read that. That is a dispute involving French company with an Argentina registered address under Article 123 LSC. Later, it will show you what means this abbreviation. Raising the question when a service of process could be validly be made at the local registration or has to be effected at the company real domicile in France. That's a typical case that there is a notification, and it's not a notification where is where is placed, but it's in Argentina because it had a filial or something. Then it gives you a bit more information, and this is here that coger that article do not authorize, and at the end it say that it is necessary notification according to the rules of the convention. That's all. Is that enough for your paper? No, you have to read, of course, this decision. But it's enough to say, well, I am not interested in notification. I'm not interested in that the next one. Or maybe, oh, that's exactly what I want. And that is enough in order to have an idea, and later you have to rate the decision. Then it gives you the passage, the most relevant passage. Here states something of Spanish. La sala advirtiendo que ni la demandan, blah, 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 blah. That is Spanish, because we wanted to give the original language. Because we assume if you are making a research in Argentina, well, I think you can understand a bit the law. And we want to be precise. This is the only information that we keep in the original language. The rest of the information, it is in English. Yes.
You said choice of law questions. This is border of procedural. Is international civil procedure provisions also included?
I'm sorry, that is true. I have to say maybe private international law question, that is procedural and choice of law. But what is important is at the beginning, that was our question. What happens if you introduce a decision that had nothing to do, for example, procedural rules? Well, it is able to say you, although that is not choice of law, but it say you what is about that because it's procedural, it's a procedural thing. And that's what it's better, I think, not to focus only choice of law because you don't know what you will have. And it gives you just, a summary. But what is important is that it focus only that. It's not focused in family law or in employment law, in issues related to employment. For something like that, we have to change our tool, but it could be possible. But that is for the future.
So we have this, if we have more time to conduct the research, we would try to expand to other realms. And now I'm trying to expand to arbitration just to try it out. But the interesting thing is that in the data collection, of course, we give priority to choice of law cases, applicable law, but applicable law issues, they come in all sorts of cases in many different forms. And especially, so there are many cases that touch upon public policy or overriding mandatory rules, and they might not be straightforward cases or very organized in terms of how the rules work. And even so, the case analyzer performs well. And in the data first, so of course the name is choice of law, but we add, as long as there is some connection to the jurisdiction and the questions that we are asking for that jurisdiction, we are willing to, so it's a private international law tool for court decisions. And whether this can be adapted to other realms, it would remain to new researchers to customize the case analyzer.
Perfect. Yes, the idea with this project is showing the SNF, but it is possible. We choose private international law, but we can choose, I don't know, employment law or any other area of law. But in this case, the tool is designed for this specific thing, but it can, for example, procedural things, it can give you also information. Well, also, that is the provisions here. Sometimes, as I say, LSA. What is LSA? La Ley de Sociedades Argentina, Ley General de Sociedades. That is what here is what is important is that we are able, not always, but in many cases able to give you the whole name. Why not always? Because sometimes the judge, they use the local abbreviations and the machine is not able to understand what exactly is that. In a moment, I will talk about the problems that we find, but this is a general view how it works. It gives you what is the main important, the private international matter discussed, can a foreign company register under Article TAR, validly be served in Argentina? And as I tell you before, it gives you more information. Give you information about the court position, issuing country, legal system, etc. And as you can see, there you have, I think, a summary. You can see that later. What else? How work does internally? Well, first of all, we work with GPT-5. That is the engine behind the case of the case selected. However, I have to say that is currently, because in the past we were working with ChatGPT-4 and we also tried other LLMs. After discussions, we decide that is the most appropriate and the most important. If we want, we can change. Next year, we don't like GPT, and we can change internally and use another one. That's something that we can do. The second thing that is important to say is that the tool use machine learning pipeline to process information. That's a nice word, but it just means that we provide prompts. The idea is that it has to determine, for example, choice of law provisions. And we can guide with specific instructions how they can to approach the question. For example, give me abbreviations or many other instructions. In a moment, I will give you an example of that. And prompt chaining, that means that we need to start the response. First, as you can see, response 1, response 2, response 3, response 4. What is interesting is as it take for when it responds response 4, it takes into consideration what it responds in 3, in 2, or in 1, so that we gain coherence. In this way, we avoid hallucinations or problems with that information.
If I may interrupt you, I think this is the main aspect or highlight of everything that we have done, because you could say, why don't you use ChatGPT directly? But the thing is, you will not know what rules are being applied behind this user face interface that ChatGPT or CoLD uses. And every time that you try to pass the case for analysis, you might get different results, or you might get inconsistent outputs. And everything that we have done, the rules that we have applied, is to have this very connected structure so that the results are reliable. Are they 100% reproducible all the time? No. Because no one knows how a large language model works and how, what is behind this black box. Here in Switzerland, if I'm not mistaken, at ETH, now they are building, or they just built the Apertus, their own open AI system that in theory you should be able to know how this black box works. But we have tried to, and Daniel could say more. We had a partner at the University of Zurich, and we tried many things to see if one of our systems could develop our own large language model. And I'm not going to say that we gave up, but we realized that we could do things in a simpler manner using proper rules. And this is what
we'll talk about that later. Prompts, instructions. Well, here we have that. And that's why I started working with the SNF.
Yes.
Because it's, of course, free. Every person can use these prompts, and that is here. I can give you that, and you can see that later. And here you can see all the instructions that we gave to the model. And if you want, you can repeat that and make your own tool in your house. Anyway, so that I make here a nice graphic. And first of all, we can see that later, huh? And this information, I will take that to my house. Well, first of all, we put here the information, a PDF. Then it starts with the prompts. You have a list. And some prompts are instructions like that. Strike rules related to choice of law. Use abbreviations and many other instructions that we give. But also we are able to give that more information. What I say, how can be better approach. For example, definitions. We use sometimes as lawyers, we have to use a difficult language, no? Because so maybe we make manual. It should be very difficult. Well, for this kind of situation, what we do is explain it what we are thinking in order to reduce the mistakes for the machine. For example, they are over dicta, dissenting opinion. We can give her information. So, for example, in many common law decisions, there is not only a decision, but there is dissenting opinions. And for that case, and we will see that for the case of common law provision, we say, hey, you have to take into consideration that there is maybe an opinion, dissenting opinion, and you have to differentiate. And these kinds of instruction we are able in order to reduce errors. Well, then come the analysis here. The model combines the information, and as I said before, step one, so answer one, answer two, answer three, and they are related. They are interconnected in order to reduce mistakes. Here you can see previous outputs will be considered, and certain outputs activate specific instructions. What I said before, the first question is country of origin, the second is a legal system. When it's common law, there is a special rule for common law because we know that there are some, it has a specific peculiarities, this kind of legal system. And I will explain you later what are exactly these the different instructions. And oh, sorry, it's okay. And well, that is here. And then the question is, okay, Rorick, come on. You talk here, I see your graphic, and there is a nice robot, but hey, wait a minute, that is my name in this paper. How good is that? Can I trust in your tool? Because at the end, I am a judge and I am a lawyer, and it's important to know if that is good or is not good. Are there hallucinations or not? Well, that was exactly the same question that we had. We were in a period of training period. In a training period, we were developing these instructions. And sometimes it goes, no, when you had that, the answer is not good. And we will travel and discussing. And so at the end of the day, one day we said, yeah, okay, we have to stop. And we have to make an evaluation in order to see if that's really good or not. And that is because I can show you that. What we did after a training period of what we decided is to take 5 countries: Argentina, Brazil, India, South Africa, and Switzerland. Why these countries? Well, first of all, because they are different legal systems, common law and civil law. And second, and that was important for us, the language. We wanted to see if it's possible to work with different languages.
Perhaps also global south. It's the BRICS. It's, like.
Well, they are, of course, you are from Brazil, and so, okay. But at the end of the day, we decided that these countries, and it was about more than 50 decisions. And what we asked is 5 legal experts, one from Argentina, one from Brazil, from India, and so on. And the idea is that they have to check that and evaluate that. By that evaluation, we use a scale for 0 to 100, a passing mark of 8. And here, hey, we were very strict here, white lines, because we wanted bias for that we are influenced with the response of the machine. We kept strong white lines. For example, you have to first read the decision, then try to respond, and then check the answers. Or you have to evaluate to just one try. You put, and there is not, oh, today the answers are not so good. Maybe I try tomorrow. No. You have to evaluate in one day. And many other things in order to be the most objective as we can do. I can tell you that we use different methodologies, and we'll explain that in the next 2 minutes, because in 2 minutes it's already done. And here are the answers. Here are the marks. We evaluate, as I say, that from 0 to 100. Well, we first evaluate the first two issues. Issue is country, that is, what is the country of origin? And the second question is legal system. What was the result? From an average, it obtained 100. Not bad. And legal system, 99. There was one situation, but it was not able to detect the legal system. After that, because it was a decision from South Africa, I tried in Switzerland again, and it was correct. Again, correct. Why something like that happened? We don't know. When you talk with the expert, they say temperature. Temperature is a word that they use with something like I have no idea. Because we don't know how really works. How works at this LLMs, what is ChatGPT. What they say is that sometimes internet is like that, and then the results are not perfect. And that is important, but we make mistakes. Huh? That is very important. That's just an assistant, but we don't want to replace a human being. But in the second, the relevant choice of law passage and the choice of law provisions mentioned. In the first case, the score was 90. That means sometimes 95, 100, but sometimes 70 and less. And here in the choice of law provisions, 83. Not so incredible. What was the problem? Here was normal, but here the problem was decision from common law countries. Because it's not even civil law. In civil law, Article 121 for the Act of Private Commercial Law. When it's common law decisions, the problem is that they are authorities. That is case law and authors, and sometimes it doesn't recognize the style of citation of these decisions. Well, that is what we are assuming. There is a solution. Yes, there is a solution. You can make a prompt explaining what is the style of situation and the way how they mention the citation or the abbreviation, and maybe the results will be better. But we don't know, and we don't have the resources in order to do that with all countries in the world. But in the case of Argentina, it was possible. We tried that, and it works if you make a list. But in the case of common law countries, as I said, that is something that is not entirely clear. However, 83. And then the last text, that is the conflict of law issue and the core position and abstract of the decision. In the conflict of law issue and core position, this question, it was 86. And in the abstract of the decision, the notebook was 85. We are writing right now a paper where we explain in detail exactly what we find, that not only the problems, but also what we think is the ground of these problems. And we are finishing that in the next month or something like that. And there you will have not only more information about our evaluation, but also we will publish a link with all the pros. Because the idea from SNA is that, okay, they give us financiation, but the idea is that later people can use that. And the way the corporate rights is totally free. That means that you can use all our props, you can make money with them. Or you can change that and say, no, I don't want choice of law, I want employment law. You can make everything and build in our tool or in our product. And well, just to finish, the average total was 91. That is no so bad. And that is all, ladies and gentlemen. That is our total case.
I would like to add that without Rorick, this wouldn't be possible. So thank you, Rorick, for being so patient with the AI assistant, because otherwise I alone, I really well, I have I've distrust in this tool. Even Daniel was also very skeptical, like, oh, not sure if this is going to work, and then you don't know whether the effort is pays off. What he's presenting now and these nice results is actually a very good surprise to all of us. We had 6 versions of the case analyzer. We intend to release one more. We didn't want to rest, because when we release new things, sometimes things go wrong. We didn't want to do any impulsive things before this launch. But we since the technology keeps changing, we can always do more, right? And Rorick, you are amazing. Thank you so much for doing all this methodology behind the scenes. And yeah, I guess one thing that I mentioned in the beginning with Dominic is that we started with Swiss cases, right? And then we added the other countries. And for Swiss cases, we had very established ground truths. So ground truths is precisely what a human would answer, and then we would compare the answer from the human and the machine answer, the output. And the thing that sometimes we forget as humans is that if you have an assistant and you have seen this with your team, this is will also make mistakes. You have to instruct and say, oh, not like this, or here you were very generic, or here, and the machine. So sometimes we even evaluate the machine with higher expectations that things should work perfectly all the time, but not even us humans or research assistants can do that. So this is what we have learned. So it's a very interesting process.
Mhm.
Thank you so much.
Right now, what